Hi, everyone. Harry here to talk about the government's response to Trump's motion, joined by his two co-defendants in Mar-a-Lago, Walt Nalda and Carlos de Oliveira, for an extended continuance of that case, ostensibly because of dealing with classified information. All right, so there is now, in part of the general schedule before Judge Cannon, we all remember who she is, some skirmishing involving classified documents. And at the reply stage of that briefing, so it's Trump files something about classified documents, the government responds, and at the reply stage, they come in with we need a huge continuance for this, that, and the other reason. And then they say until at least November 2024 without explaining anything. I mean, it wafts off the page. Obviously, it's a blatant effort to get over the election line. But there's no real legal basis for that, so they just sort of say it. And this is their hometown court, remember. This is Judge Cannon. And in fact, how she deals with this motion will be a major test. She already has indicated that she's, put things on hold to wait to hear about just this response from the United States and the motion itself. But she had no problem just provisionally suspending the schedule she had already set. All right, so now Trump comes in at the reply stage and says we need a continuance. There's just so much discovery we haven't gotten, and we're being drowned with it even now. And there's this terrible problem, which is there are a few documents that we have to go to Washington to review, and one of the lawyers doesn't yet have the proper clearances, and oh my. Okay, so the special counsel, so Jack Smith, makes his response. It's very methodical, just kind of goes one foot in front of the other, and really leaves no stone unturned. Just makes it clear that all the points either have carry no weight in terms of a big delay, or are just false. All right, so you don't have to go into each and every point of contention, but a few things are important. This is a basic theme that's good to understand in general. The charges here are for carting away national defense information without authority, and then obstruction of justice involving the Nauda and de Oliveira. And if you stop and think about that for a moment, it doesn't really turn on, as certain big espionage cases, for example, might, the exact nature of the classified information. It just has to fit the definition under the statute and regs for what national defense information is. Basically, information that could be, sensitive or important for our national defense purposes. It's sort of, even that's sort of outside the normal classification whole long rubric, etc. So the United States points out, look, it's not, there you may have to look a little bit at the content of what's there in order to try to rebut or defend against the charge that we're certainly bringing, that this is national defense information, but there's not very much of this involved. That's a very small part of the case. The case turns on, did he take the documents? Did he know he wasn't supposed to take the documents, or other mental issues? I actually want to put an asterisk on what I just said, because I think that there's the intent showing they have to make is not very high. But in any event, the point is that the charges are not really about the how serious the national defense information was, or what the damage was, as it might be in an espionage case. It's just do they can you check that box? So that's one point the government reaffirms here. Second, they go through chapter and verse all the discovery they've turned over, how thorough, how organized it is, how excessive it is, way more, especially the thing that you really want if you prepare a defense, the transcripts of witnesses. They've given them even transcripts of people they won't call at trial, non-witnesses, and it's all been very thoroughly prepared and the like. So the idea that they're have been sparse or at all grudging really doesn't hold up. Trump at one point says, and they just deluged us with all this new stuff. What really happened there is they gave a new chunk of stuff having to do with NALTA, which they had to hold off on because NALTA's lawyer, you recall, there was a whole delay until he even got local counsel, until he had officially been arraigned. So that explains that. They don't have to try to canvass all of government for things that might be discoverable, maybe because they're exculpatory or the like, but they're doing it and sending out so-called PSRs. But there's no legal obligation that gives rise to. And I think those are the main kinds of, basically, there's only a very small part of the case that concerns what he's asking about and the specific content. And man, oh man, he's gotten so much here, more than he's entitled to. Okay, so it really, to me, if you go through one foot in front of the other, it blows the motion out of the water. And then that's without even confronting the really ham-handed gambit of saying we need more time, so let's make it after November 2024. That's such an obvious effort to really plays with an open hand there, showing what they are about. So to me, this is going to be a really important test of Judge Cannon. He's asked for 7 months. To read the DOJ, he's entitled to nothing. Cannon could get, if she gave 7 months, it would be an outrage. If she even split things and said, well, okay, we'll give 3 or 3.5, that's already really getting close to the finish line that he needs to get to in order to get nudged over the November line. And with this weak a showing, there's really just no good basis for that kind of chunk. It might be indeed that the reason they just said after November 2024 is they think that might be too much to hope for, but maybe they can hope that she would go halvesies, say. If she does, or if she gives any kind of real delay here, it's wrong, because the justification, the record hasn't been made for why they need it, and it's troubling because the thing about the Mar-a-Lago case is the most important case, the case that's likely to go soonest, and most important just in terms of the response to what Donald Trump did to the democracy, is the January 6th case. But the Mar-a-Lago case is the most open and shut case. It's really very clean and should result in fairly quick conviction. And so if Judge Cannon is pushing that so it doesn't happen until after November, it ain't good. Now, there's a possibility for the United States to try to challenge her. To date, they haven't done it, but she's already got a record of having made bad rulings for him and being reversed for it. So if they get something that's kind of beyond the pale, they can move to recuse her, but it would be hard in that instance, I think, to reverse things and get a new judge who actually reduces the time they've already been given. So if she really gives a lot of running room here, that might be hard to reverse, and it would be a real showing of some combination of lack of sort of, strength in running her calendar, and possibly, you hate to even say it, but the evidence to date has been sadly strong, maybe even, putting her thumb on the scale. So let's watch for this, see what she does now that the papers are all in. There really ought to be a hearing where she pushes on them and says, look, here's what the DOJ says, what's your response? They won't have a good response. So this should be the kind of thing that she, gives them no quarter for. And the worry, of course, is she'll give them, more than that, either meet them halfway or go all the way. And that would get very close to foreclosing the possibility of a trial in this most open and shut case before November 2024. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.